Officers learned the defendant was not an eligible driver due to a license suspension back in February of 2024. Officers learned the defendant had 5 prior convictions for failure to obtain liability insurance on his license. Officers asked the defendant if he was aware of his driver's license was suspended, and he advised he was. However, he did not know how it was suspended, saying he was working on his SR-22 and reinstating his driver's license.
Martinez, I'm going to find that there's probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to drive.
Pay attention, because this is the moment where the judge shifts into what I like to call the zero tolerance speech. You'll recognize it immediately. Suddenly the judge starts throwing out extreme hypotheticals, medical emergencies, natural disasters, burning buildings, bizarre 1 in a million scenarios, anything and everything that could possibly be used as an excuse.
I don't care what you have to do in this life. I don't care if there's someone having a heart attack and you have to go save them. There's a burning building and you have to save 50 kittens. I don't care. If you don't have a license and liability insurance, you're not allowed to drive. This is an affidavit that you're going to be signing with me. And if I find that you do, every single time you drive, it's a contemptible action, punishable by up to 6 months in jail and a $500 fine every time you drive. Do you understand?
Yes, sir.
If you want to drive, go get a license, get liability insurance, and I will be doing backflips. So happy I will be to take this off. But if I find that you do, it's really not going to go well for you. Do you understand?
Yes, sir.
You have the ability to hire a lawyer.
No.
I can have you fill an application. I'll take a look to see whether you qualify. Deputy Miranda will give you an application. I'm going to have you come swear to us that you're not going to drive. I'll get you to Victoria Sign a reset, and then we'll have you take a seat. Please.
You're reviewing file law conditions for driving?
Yeah. Yeah. With both. No driving and then no without insurance as well. Ma'am, you're charged with 2 cases. You're charged with criminal mischief, and you're also charged with interference with the emergency request for assistance. On the criminal mischief, you're facing up to 6 months in jail and a $2,000 fine. And on the interference case, you're facing up to a year in jail and or a $4,000 fine. I also see she has an open warrant.
Yes, Your Honor. I see that as well.
You also are charged with, I guess, the following day, you picked up a terroristic threat. On that case, you're facing up to 6 months in jail and or a $2,000 fine.
I do that, Tony.
First, we're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to
I
you.
get that, Tony.
Let's do probable cause and then we'll. Yeah.
On April 13th, 2025, officers were dispatched to a disturbance. Dispatch stated that the defendant knocked the complainant's phone out of her hand and then left the location. Officers made contact with the female matching the description given by dispatch. The female stated that she was the victim, but she was not talking without a lawyer. Defendant gave name and date of birth, but would not provide an ID card. Defendant was detained and taken back to the incident location. Complainant stated she reported a criminal mischief on the defendant the day prior. Complainant advised to dispatch that he would later call back and report the incident, which he received video of the incident proving that the defendant had damaged his vehicle. Complainant advised today he went to the store, and when he returned, the defendant was on his porch. Complainant asked the defendant, "What are you doing here?" After you broke my window of the vehicle, of my vehicle. Complainant advised he told the defendant just to sit there while he called police. Defendant then left, but returned while he was on the phone with dispatch. Defendant knocked the phone out of his hand and caused damage to the phone. The value of the phone was $300.
And what about the terroristic?
So the terroristic threat, Your Honor, and this is the same complainant. On April 15th, officers were dispatched to a telephone harassment. Upon arrival, officers spoke with the complainant. Complainant stated that he had received a phone call from the defendant via a Google phone number, threatening to shoot up her home. Complainant stated she was confident the caller was the defendant and expressed her desire to pursue criminal charges. Further investigation revealed that the defendant had been arrested at the same location on April 13th for interference with an emergency call and mischief. She was out on bond for that incident.
Should be given conditions not to go back.
Let me check here.
Ms. McKnight, I'm going to find that there's probable cause to go forward with the case. I don't want you to have contact with this person.
It's not for them. I'm hurting about that person.
I don't want you to have contact with this person. Do you understand? Are you sure? You understand?
Yes, sir.
Okay, I don't want you to go where this person lives. If you do, it's not going to go well. I will revoke your bond, put you in jail. Do you understand?
Yes, sir. I have evidence for all of that.
And I'm going to give you a lawyer today. I know that there's two sides of the story. You can give your side of the story you can give your side of the story to the lawyer, but I don't want you to have contact with this person. That's it. Do you understand?
So when it comes down to the child, do I have to come back to court just to get in contact with him?
I don't want you to go to his house.
No, I'm talking about, do I have to come to court so I get in contact with him because we have a child?
We'll figure that out. Let me get you the lawyer and then we'll figure that out. But just don't go to the person's house. Don't have contact with him. Don't call him. Don't use anybody else's phone to contact him. It's not going to go well. You need to understand that if I revoke your bond in this case and I set them at $5,000 to $10,000 and you don't have anyone to post those bonds, you will be stuck in there until these cases are over. Do you understand?
Yeah.
Okay. Deputy Miranda, do you mind? You know what? Don't even worry about it. I'm going to appoint you a lawyer today. I'm going to have you sign a reset with Victoria, and then we'll have you take a seat in the jury box while I find you a lawyer. Don't leave until you sign our bond conditions. Okay. Mr. O'Neill.
Morning.
Sir, you're charged with terroristic threat of a family or household member. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. All right.
Good morning, Judge. Just 1 second. Pulling up right now.
Okay.
So, I thought I was supposed to have an attorney here today.
Did you hire one?
No, the judge that I talked to said that I could have.
That was for purpose of magistration, but it doesn't carry with you until the end. You don't have a lawyer at this time.
All right, Judge. On April 12th, 2025, officers responded to a family disturbance call in Harris County, Texas. The officer ID'd the complaining witness by their Texas ID card. The complaining witness stated that the defendant threatened to shoot her. The complaining witness ID'd the defendant by his Texas driver's license. The complaining witness stated that she is the defendant's daughter and they all live together in their grandfather's residence. The complaining witness stated that the defendant threw her clothes outside. The complaining witness stated she asked the defendant to go get them. The complaining witness stated that the defendant stated, "I have something else for you," and then took his hand and pointed it at the complaining witness, stating, "I'm going to shoot you." Complaining witness stated that they were in fear due to multiple guns being in the house and the defendant having a violent history. The complaining witness stated she observed the defendant holding a black long gun. The officer detained the defendant. The defendant refused to ID himself, repeatedly stating, "What is going on?" The Miranda rights were read. The defendant denied all allegations and stated his daughter, the complaining witness, was lying. Defendant advised that he hadn't seen the complaining witness all day long because she was at the hospital visiting her mother. The officer inquired about this, and the complaining witness stated that she did not go to the hospital. It was only her grandfather who went. The complaining witness stated that she was home and the defendant did see her and threaten her.
All right, Mr. O'Neill, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you as a condition of your bond not to have any contact with this person and not to be in possession of weapons. These are your bond conditions. If you
watch enough court hearings, you'll start to notice a pattern. Whenever a case involves both family relationships and firearms, judges tend to shift into maximum protection mode almost immediately. The defendant may want to discuss property, living arrangements, personal belongings, financial concerns, or other practical issues. But the judge's priorities are often very different at that stage. The court is usually focused on one question above all others.
violate these conditions, I will revoke your bond, put you in jail.
Absolutely.
Do you understand?
I don't have.
Just don't say anything at this point. Just don't have any weapons, don't have contact with this person. There's a protective order that has been issued in this case. I would get to know it. If you do something to violate the protective order, they will potentially file additional charges against you. Do you understand?
Yes.
Okay.
What about the house? That's where all my stuff is at.
What I'm going to do is I'll appoint me a lawyer today. You can talk to the lawyer about what's going on, but I'm going to do everything in my power to protect everybody in this at all costs. You understand? Okay. So look,
She can go wherever she wants, but I'm just asking.
let's do this. Let me appoint you a lawyer. You can talk to the lawyer and we can go from there. Now is not the appropriate time to go through this.
I've been staying at a shelter.
Okay, hold on.
And
I already have an application. So Vic, do you mind appointing him? I already have an application on file. For now, what I'm gonna have you do is I'm gonna have you sign a reset with Victoria while you take a seat in the zero box while I find you a lawyer. We'll have you talk to this person and we'll go from there.
did the reset happen in a few days?
We usually do like a month.
Months?
I'm gonna have you talk to a lawyer today. Good morning, Mr. Schaefer. Sir, you're charged with aggregate theft. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. All right.
Thank you, Judge. The officer made contact with the loss prevention officer of O'Reilly's Auto Parts, who stated that he received an anonymous online tip about a possible theft regarding one of the employees from the 3498 FM 528 location. That's an address. The tip stated that the defendant had made 2 fraudulent returns and kept the money from them. The first return was back on August 2nd, 2024 for $316.50 for three brake rotors. The complaining witness was able to contact the customer and they advised they did not return the rotors. The other return was on January 16th, 2025 for $179. The complaining witness contacted that customer and they also advised that they did not return the product. The total of the 2 returns was $495.50. The defendant admitted to the theft in a written statement. Complaining witness provided the 2 fraudulent receipts and listed on each was Schaefer's unique counter number.
Okay. Mr. Schaefer, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you now as a condition of your bond not to have contact with this O'Reilly. There's not a specific complaining witness, right? So I'll just go into O'Reilly's. Do you understand?
Yes, sir.
Okay, if I find that you do, if I find that you pick up a new case, it's not going to go well. Do you understand?
Sure.
Do you have the ability to hire a lawyer?
Sure, I do that.
Okay, we can have you fill out an application. I'll look to see whether you qualify. Deputy Miranda is going to give you an application. I'll have you go to Victoria, sign a reset. We'll have you take a seat. We're losing spots.
I only got one more minute and I'm supposed to come in.
Okay, well, there's one.
Bond conditions.
Okay, so we'll do all that. We'll have you take a seat there and then let me start. Okay, please.
I'll look the next one that could be ready. That's fine. Theo, come on up.
Sir, you're charged with evading arrest or detention and theft. On the evading arrest, you're facing up to a year in jail and or $4,000 fine. On the theft, you're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Thank you, Your Honor. On April 11th, 2025, officers were dispatched to a theft in progress call in Harris County, Texas. Officers were given a description of the defendant by an Academy employee.
A 17-year-old running through a parking lot and allegedly tossing a paintball gun into the bushes. This is exactly the kind of case that often causes a judge to shift gears up until this point. The hearing may have been focused on charges, evidence, conditions of release, and legal procedure. But then something changes. The judge starts looking beyond the immediate case and starts looking at the person standing in front of them.
The officers observed the defendant walk out of the store passing all points of sale. The officer attempted to detain the defendant for investigation for the alleged theft. The defendant initially complied with the officer directives. As officer grabbed the defendant's wrists, the defendant began to pull away and evaded through the parking lot. The defendant eventually tired out and officer detained him without incident. The defendant evaded approximately 1,271 feet. The officer confirmed with the reportee that the defendant detained was the one who stole a paintball gun, and officer located the merchandise in the bushes at the Olive Garden where the defendant stated he dumped it. Initially, the defendant denied taking anything from the Academy, but when confronted with being told store cameras caught him in the act, he admitted it and led the officer to where he dumped the paintball gun. The paintball gun was retail priced at the store for $140.
Mr. Steele, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you now as a condition of your bond not to go to any academy. Do you understand? How old are you, sir?
17, sir.
Are you here with anyone today?
Yes, sir. I'm with my sister.
Okay. I'll appoint your lawyer today. All
Yes,
right?
sir.
Don't get in any more trouble. I don't want to have to put you in jail, you know? If I put your bond at $5,000 to $10,000 and you don't have anyone to put that kind of money up, you'll be stuck like Chuck, man. This is not a good way, all right?
Yes, sir.
So what I'm gonna do is I'm gonna have bond conditions created for you. Don't get in any more trouble. Don't go to O'Reilly's. What are you doing with yourself? Are you in school? Are you in high school?
Yes, sir. High school. I'm in 10th grade and I'm trying to find a job right now.
School. That should be your one and only gig, you know? That should be your full-time job because the most, you want a paintball gun? Money. You get money with knowledge. You get that with school. That's your full-time job. Do you understand?
Sir.
All right. I'm gonna have you sign a receipt, Victoria. We'll have you just take a seat in the juror box while I find your lawyer, okay?
Yeah.
Please. Good morning, Mr. Garcia. Sir, you were charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Thank you, Your Honor. On June 7th, 2024, officers were dispatched to the complaining witness's residence and met with JV, a minor. The defendant is her older brother. They were having an argument because someone went through his items in his room. The defendant kicked her in her midsection area, causing her to fall on the floor and struck her with a fist several times. Her younger brother also witnessed this. She felt pain. Defendant left the location before the officers arrived. That concludes.
This is old, huh?
Yes, Judge.
This is from 2024. We're just now getting it? Is it a 2B?
Yes, Judge, it must have been a 2B. We do have another offense from a 2024 date as well, so I'm not sure what brought them in this day.
Mr. Garcia, I'm sending you for a drug and alcohol test. I want to know what, if anything, is in your system now and you're to come back. If you ever take off again, I'm going to make your bond extremely high. No more PR bonds. Do you understand me?
Yes, sir.
You are on bond for a felony as well. Will keep my county safe at all costs. You understand?
Yes, sir.
I'm going to appoint your lawyer today, but I'm sending you for a drug test. You must take the test and come back. You understand?
Yes, sir.
All right. I want to send him for a test.
Can you send these charges?
Judge, we do have a few more agreements, however, the attorneys are not.
Oh. Okay, we'll wait. Then Mr. Lopez, you were charged with criminal trespass. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Thank you, Your Honor. On April 11th, 2025, in Harris County, Texas, officer was working patrol when he observed a motor vehicle that matched the description of a vehicle that was recently stolen by 3 armed Hispanic males.
This is a fascinating moment in the hearing. When you hear allegations involving a stolen vehicle and a stolen firearm, you might immediately assume that more serious charges would be on the table. That's why the judge's reaction stands out. Almost immediately, the judge begins questioning why certain charges were, or were not, filed. And that's not something casual observers get to see every day now. It's important to understand what is happening here.
The officers conducted a traffic stop. The defendants disregarded officers' verbal commands by staying in the vehicle. The driver continued to disregard commands by putting the motor vehicle in drive and operating the motor vehicle through the parking lot. More specifically, the driver drove approximately 20 miles per hour toward Officer Martin and his motor vehicle. The driver continued to evade for approximately 2 miles until the vehicle was damaged such that it could no longer operate. Defendants were detained and a stolen handgun was located under the driver's seat. The complaining witness mentioned that he was robbed at gunpoint by 3 Hispanic males who took his motor vehicle without his consent.
Charge anyone with the aggravated robbery?
We do not, I do not see that here. I'm not sure.